Good evening, everyone. Thank you very much for your patience. You realize why it was, because our main speaker has just arrived. So we're very pleased and delighted to see him, Ndjodi Ndeunyema. How we're going to do it, we're going to have Ndjodi speak first for maybe give a presentation for about 20 minutes. Then that will, and I'll introduce him. And then that will be followed by, we're very privileged to have Bience Gawanas with us, and I'll introduce her then. And she'll respond to some of the points as she likes to Ndjodi's presentation. Then we'll open it up to you, both on Zoom and the audience here, to ask questions. Thank you for your patience for our starting. So Ndjodi Ndeunyema is a UNAM law graduate. I met him about 9 years ago when he was in his final year, and he was editing the UNAM Law Review, and I came in as an editor then. He graduated from UNAM in about 2013. He was the first Rhodes Scholar from Namibia to be accepted, and he went to do a DPhil in law at the University of Oxford, Linacre College. So he's multi-talented and he's dynamic, and I'm delighted that he made it in time for tonight. He's an editor, he's a researcher, he's got 3 master's degrees from Oxford, he got his doctorate, and for that he was awarded the best prize. He won a particular prize for the best law PhD from Oxford in 2019, 2020. And that thesis was reworked into this book, which is on sale tonight at a special price. And it's called Re-invigorating Ubuntu Through Water, a human right to water under the Namibian Constitution. So he's a scholar. He's published many articles in peer-reviewed international journals. And at the moment, he's in, well, at the moment he's here, but otherwise he's a trainee solicitor in London with an international corporate law firm. And he just passed his exams with a distinction. And he's a very good speaker and very articulate and personable. You'll enjoy hearing him. So I think I've said everything at the moment. So Ndjodi, can I ask you to come to the front, or you're working your presentation there? Thank you.
Thank you so much, Helen, for that exceedingly generous introduction, which I think creates more expectation than perhaps I'll be able to fulfill this evening. Good evening, everyone. Thank you so much for making the time, and may I profusely apologize for the delay in starting. I had some logistical challenges. We had an event yesterday in Ongwediva, and as things happen, I missed my flight this morning, so I had to make alternative arrangements to arrive in Windhoek by different means, with gratitude to my brother for coming to my aid. I have a PowerPoint presentation, but while that is being set up, I'm really glad that we're having this conversation, both in person as well as with those who have joined on Zoom. And I really do not want to take up too much time in terms of the presentation. I'd like us to really engage with one another on the subject matter of my talk today, which is my book, Re-invigorating Ubuntu Through Water, a human right to water under the Namibian Constitution. Perhaps it's also helpful to just give a brief background as to the coming into being of this book. Yes, Helen is quite accurate that the outcome of my thesis, my doctoral thesis, was published as the book, but there is quite a gap between the publishing or the writing and defense of a thesis and ultimately publishing a book. And I must at this stage delight in stating that Helen Vale was my language editor for my doctoral thesis. So I think the Subedi Prize, which I won for the best law thesis at Oxford University, is in no small basis because of her efforts. So I just wanted to acknowledge her. And we have fantastic. Thank you for the PowerPoint presentation. I'll just give you a sign when you should move on. Yes, so really I'd like us to engage as far as possible. I have a couple of slides just to walk us through some of the key themes that I will be touching on. And the primary focus area will be on issues related to water, in as much as the book has various substantive focus areas in terms of law. But because of this audience, presumably scientific audience, we'll try and look at water from a more scientific point of view, in as much as I do not profess to be anyone with scientific expertise, but would rely on the engagement of the audience. Moving on to the first slide. The next slide. It will come up in a moment, but it just demonstrates the water profile of Namibia to set the discussion in context. So of course, we have contemporary water needs and challenges, as well as debates that have festered, particularly over the last few months. I am particularly struck by the incidences of river crocodiles in the Okavango, which are often reported as snatching babies, sometimes grown adult people who risk life and limb to access water resources, and in the process fall prey to that. So I'll touch on that at a later stage in the presentation when I touch on the scarcity issue. There are often issues with disconnections of water for non-payment. The indignity of water scarcity, that is a reality for many Namibians, in as much as there are efforts that are ongoing at ameliorating that, as well as the water for profit debate, which I think was recently at the forefront of discussion when the newly appointed ombudsperson weighed into the debate and questioned whether our water utility should be a for-profit entity. So in that sense, the book is timely, but I also regard it as timeless, because the issue of water will remain with us, no doubt, for many years to come. At the same time, there's a lot of water potential. I highlight there the discovery of the Ohangwena 2 aquifer, the prospects of desalination, and the efforts that have been put in place by government in investing in water catchment, most notably the Nekotral Dam. The book, of course, doesn't navel gaze. It seeks to be solutions-centric and forward-looking, with the primary purpose of bringing dignity to all. In so doing, the book is focused on an anthropocentric approach to the issue of water, that is water for purposes of personal and domestic use rather than commercial interests. And the reason why the book is focused on water for personal and domestic use is because in researching this subject, I tried to establish whether there is any case law on water rights, and so forth in Namibian jurisprudence specifically. And I came across 3 particular cases that have come before our courts, our superior courts in Namibia. One is Namibia Plains farming versus Valencia uranium, and this relates to water for commercial farming versus water for mining abstraction. And in that case, the parties sought to vindicate their rights for commercial reasons. Another case was the decision in Namwater versus Alsancure farmers, where there was an allegation of breach of contract in the context of water for purposes of wine production, commercial wine production. Another case was a decision of 2005 of the Namibian High Court, where of Kamanya versus Smith, a Omangeti farmer at the time, he sought to drill a borehole for reasons of farming, and Mr. Smith did not deliver as agreed, and he sued Mr. Smith, and effectively Mr. Kamanya was bringing arguments related to his water rights in the context of this commercial agreement to drill the borehole. What I then asked myself is, why aren't there incidences, or is it possible for a Namibian who wants to access water for non-commercial reasons to also seek refuge in our courts? So can they bring a claim before the courts for water is to be used for personal and domestic use? And there's a clear need and clear issues as regards water in Namibia, and many Namibians suffer such indignity. So that's the context within which the book is located in this anthropocentric focus area. Moving on to the next slide. This is just an abridged argument that I put forward in the book. I aim to whet your appetites, no pun intended, with the view that you do indeed engage with the book with this framework argument in mind. And I must say that I have sought in particularly reworking the thesis into a book for general consumption to have you in mind, the non-legal specialist, particularly, and someone who can at least consume the content therein with a sense of curiosity. So basically, I arrive at the conclusion that there is a court-enforceable human right to water under the Namibian Constitution. I imply such a right because it's not expressed in the Constitution from the right to life in Article 6 of the Namibian Constitution. I argue that our understanding of life that is restricted to issues of, say, for example, death penalty debates, extrajudicial killings, abortion debates, and so forth, is a narrow understanding of life, which in an African setting should also include social and economic dimensions for a dignified life, which I argue is infused through this notion of Ubuntu. And of course, there are various theories of constitutional interpretation that I apply and test against this argument. Originalism, so looking at the founders of the Constitution as to why social economic rights such as water were not included in our Constitution. That's a theory that I look at, and that drafting history is relevant but not determinative of whether or not you should imply a right to water. I look at the 1982 principles, which those of us in the audience who are of older generations would know was or were the bedrock of our constitutional framework, and hopefully Advocate Gawanas can also reflect on some of those constitutional drafting history points in terms of the absence of socioeconomic rights, perhaps because it was not an idea whose time has come at the time. Textualism or purposivism, transformative constitutionalism, all these are established theories of constitutional interpretation. What I do in the book is then novelly conceptualize this notion of reinvigorative constitutionalism. And I'm sure now you can see how the title of the book is coming together in the words that are used. Basically, reinvigorative constitutionalism argues that we should reinvigorate African values in our legal culture. And moving on to the next slide, I make that argument through schools of thought, one slide back, that are rooted in decolonial theory, which seeks to realize decolonial thinking in the substance of our legal culture. And I seek to ensure that there is viability and value in the human rights projects that we pursue as post-colonial states. And there's this particular quote, which is dense, but I'll read it out because it captures the essence of this argument for cultural legitimacy of knowledge and human rights on page 63 of the book. And I state that the lack of cultural legitimacy actual or perceived of human rights amongst its intended African beneficiaries is often cited and recognized as one of the foremost challenges to enforcing human rights in Africa. Scholars have expressed the continuing incongruence between those values that have come to underpin the dominant Euro-American human rights paradigms and alien notions of justice that have come to entrench themselves in societies of formerly colonized peoples, including Africans. Moreover, top-down transplantations of legal approaches have rarely rooted themselves. At best, they yield poor results. So that is the essence of the ideological thinking behind this notion of reinvigorative constitutionalism. And moving on to the next slide, I then, within this umbrella framework of reinvigorative constitutionalism, identify the African value of Ubuntu, recognizable through its most popular isiZulu rendition of Ubuntu Gubuntu Gabantu, I am because we are, in an African context, this notion of interdependence, community solidarity, and dignity, particularly from a social and economic imperatives point of view, which then into the prioritization of water for each and every individual as a matter of obligation. That's the key, a duty that is imposed upon others. And in our context, and for purposes of the focus of the book, the state as the primary duty bearer to respect, protect, and fulfill this right to water. And this erodes this notion of negative versus positive duties that is common in the scholarship and perhaps in constitutional thinking. Moving on to the next slide. The book also sets out the socioeconomic context of Namibia. So the constitutional context is such that there's an emphasis on civil and political rights in Chapter 3, which is entrenched, as we know. Much of the debate around Chapter 3 focuses on the right to life, dignity, free speech, torture, the right to vote, and so forth. But there's limited reference to social and economic rights. As opposed to other countries such as South Africa, Kenya, more recent post-1994 constitutions. Socioeconomic rights such as water, housing, food, healthcare, sanitation, and so forth. And in actual fact, the world has moved on from those basic needs as rights that are enforceable. And current debates in human rights circles are actually focusing on the right to electricity, for example, as a fundamental right, or the right to the internet as a fundamental right. So we still have quite a long way to go in terms of catching up with the curve. But this book starts where it does and seeks to erode that view that socioeconomic matters are outside the enforcement powers of the courts or are outside the accountability structures of the courts with oversight on the government of the day, so the other two organs of the state. Moving on to the next slide. There are various comparative studies in the book that's motivated by the fact that there aren't many cases on socioeconomic matters in Namibia, and therefore we look over the fence, as it were, South Africa being a natural departure point. But the focus on South Africa is relevant, but perhaps inappropriate because South Africa, for example, has an express right to water in their constitution that is court enforceable. The decision versus the city of Johannesburg being a seminal decision on water in that context as a human right, where the residents of a township called Firi challenged the policy on water of the city of Johannesburg, and the court came out with a decision which was critiqued of, but anyways is progressive. But I also bring to the fore a Botswanan case law, for example, the Motsolonyane versus Attorney General decision, in the context where Botswana does not have an express right to water in their constitution. And this case is particularly pertinent because it was a situation where the Baswara community were deprived of the use of a borehole that the government itself had drilled. And as a matter of government policy, they were seeking to move that population away from the reserve that was subsequently created. So they were no longer maintaining that borehole. So they brought a claim of the deprivation against the deprivation of their right to access that borehole as a matter of a violation of the right to not be subjected to cruel, inhumane, and degrading treatment, which is effectively an indirect way of vindicating their right to water. Again, the Indian comparative examples implied right to water, widely rooted in the Indian context. This decision of Hamid Khan, where the state was found to have violated its duty to fulfill an implied right to water because there were water quantities that had excess fluoride. And there it was found that its duty to fulfill its obligation to provide water was eroded or negated. Moving on to the next slide. This is also just to set into perspective the fact that the subject matter of water as a human right, water as a matter of access and security, is an international phenomenon, one that breaches our territorial boundaries and is beyond Southern African and African debates. Of course, the scientists in the room would know that 71% of the Earth's surface is water, of which 3% is fresh water. The World Economic Forum consistently rates water issues as high risk factors. Climate change and water rights are at the center stage of debate. And there are increasing legal arguments for a human right to water to be recognized under international law. And that argument, if you're so curious, there's a paper I published in the Michigan Journal on International Law where I explore this question comprehensively. So it's not necessarily focused on in the book, but it feeds into those notions that exist. And of course, there are these transboundary water concerns that arise. So for example, the disputes or disputes that haven't necessarily matured to full disputes between Angola and Namibia, water catchment restrictions, and what the implications would be for the northern Namibian population. For example, a human right to water argument under international law can be made under such circumstances. The dispute between Namibia and South Africa as regards the ownership, if you want, of the Orange River, where the boundaries are, South Africa claiming that it's on the northern banks of the Orange River, depriving Namibia of equal access to the Orange River, both water resources and potential mineral deposits and so forth. Again, a right to water argument under international law can be made under those circumstances. So that is a area of potential interest. And of course, this issue of the privatization of water, it's a debate that is perhaps growing in the Namibian context, but it's one that the world has been having for many years. There are a variety of decisions under the ICSID Convention, for example, between private investors and states such as Tanzania, Argentina, Bolivia, where they had pursued a neoliberal approach of privatizing water and other utilities. And when they did nationalize, they were brought before these investor dispute settlement bodies. And one of the arguments that they had put forward was their nationalization agenda was in defense of the human right to water. I also framed the issue of water scarcity in Namibia. So of course we have a factual problem of water scarcity. We have limited water resources, but you know, one would be hard pressed to find where there is an infinite supply of water resources anywhere around the globe. You know, that is a relative notion of water availability. In so doing, I complicate this issue of water scarcity. So it's not a question of the courts, as I argue, necessarily inducing rain. That is requiring the impossible. But I look at it from the perspective of this notion of first order or second order scarcity, which is seen in the scholarship of an academic by the name of Leif Olsen, around first order scarcity, which is the physical limitation of a given resource, in this context, water. But the focus often, or the limitation often, or the challenge is with a second order scarcity, which is the adaptive capacity of societies which are faced with first order scarcity and how they manage such scarcity. And my argument is that in managing such scarcity, which requires decisions around distribution, equity, and so forth, the courts as institutions can play a role in ensuring that we manage such second order scarcity, recognizing that first order scarcity is a factual reality. And again, the book pushes back against notions of hydropolitics. So water is not a political matter. It is not an issue of charity or benevolence or goodwill. And it is in actual fact a human right which one can claim, and there are certain obligations that are put upon certain actors, whether governmental or non-governmental, but for purposes of the book, state actors are the focus. In as much as non-state actors can also be held to account for water rights. And this principle is seen in the Nairobi Principles of the African Charter on African Commission on Socioeconomic Rights, the guidelines thereof. And the claim there is that courts can be a forum for legal accountability when it comes to access to water. Moving on to the next slide. This notion of justiciability, a rather dense term, but justiciability basically means the ability of courts to adjudicate, to adjudge a given matter. And I address this in the book in terms of institutional justiciability. So the legitimacy of courts to adjudicate matters where there are policy issues at hand, where there are distributive questions at hand, where some may take the view that those who are elected as opposed to the unelected judiciary should be at the forefront because they are held to account by way of the ballot paper, directly or indirectly, or periodically. The issue of the legitimacy of courts to adjudicate such matters, as well as the capacity and competence of courts. So can a court necessarily make a determination as to the quality of water you should receive, the quantity, where a given water infrastructure project should be placed, for example? Those are issues that are economically sensitive, of course, as well as culturally laden, potentially sociologically entrenched, and so forth. And I deal with these arguments of polycentricity and so forth by advancing a model called the bounded deliberative democracy model, using the value of Ubuntu to give currency to how these distributive questions can be addressed in a court setting. Moving on to the, I think, penultimate slide. I emphasize in the book that finding that there is indeed a court-enforceable implied right to water under our constitution isn't the be-all and end-all, especially if we are to take seriously the call for courts to assist us in adjudicating such matters. And I demonstrate this through the optical illusion or the mirage of justiciability, and that's captured by the book, I feel, best. So if you acquire a copy, you will be able to admire this stunning piece of photography, which in my view captures the essence of the book. And that is not an invitation for you to judge the book by its cover, but if you did, I think you would not be disappointed. But the book basically, the cover basically is of a tree that is petrified in a body of water, leafless, with an arid backdrop. and a reflection of the tree. So you can't necessarily see where the tree's trunks begin and end and what is the reflection and so forth. The tree is in a body of water, and yet it is a dead tree, ostensibly. It has no leaves. There's a lot of metaphorical meaning in trees in African contexts, of course, because that is where we seek refuge in terms of resolving disputes. But you can't resolve this any dispute in this particular tree because it's a leafless tree, so it can't offer us shelter. So that, for me, and I'd love to hear your artistic and metaphorical interpretations of this image. For me, it just demonstrates that there's much to be done in order to allow this tree to flourish in its current setting, to ensure that it can help us resolve disputes as it relates to water in an equitable manner that ensures the dignity of all. And in so doing, I focus on issues of access to water, or access to courts, pardon me, prohibitive legal costs. So yes, you have a court enforceable right to water, but you can't feasibly enforce such a right because hiring a lawyer or senior counsel to argue your right to water case is both expensive outright and can result in a punitive cost order if you're unsuccessful against the other party, particularly against the state. So that's an inherent limitation. Esoteric court procedures, where it's a fundamental right, and yet you have to file affidavits and prepare applications in particular ways, which the everyday person who would potentially want to vindicate their rights would not be able to do. This adversarial model of adjudicating disputes that we've inherited under the common law. So both sides, or sides on the opposite ends, fighting it out with a ostensibly neutral umpire in the form of a judge. Is that the most productive way of resolving disputes? Is it consonant with African values, especially indigenous African justice systems that have existed? Perhaps looking at alternative models in that respect, issues of legal standing. So in my capacity right now, I would be hard pressed to necessarily find sympathy of the court to claim that my right to water is violated by the state. But if I want to bring such a claim on behalf of a community that is factually suffering water deprivations, can I do so? Our current legal standing rules do not permit that in terms of class action, in terms of public interest litigation. And this is a debate that has, reform in this direction has been pursued for many years by the Law Reform and Development Commission, for example, and nothing has yet come about to erode the restrictive common law approach, which has to an extent found the validation in the post-1990 jurisprudence that has been developed. Moving on to, I believe, the last slide. This is really just to reflect on the issue of what then is the content of the human right to water that I argue is court enforceable. This particular chapter is crafted in such a way that it gives you, the reader, you, the person who is potentially considering vindicating your right to water, the tools to make such an assessment. And I use a variety of sources that already exist, so there's no need to necessarily reinvent the wheel in this respect. I use the World Health Organization Drinking Water Guidelines, the UN General Comment 15, which is specifically on the right to water, and the African Commission's Nairobi Principles that I referred to earlier. In an act of remarkable innovation, developed this notion of aqua, which stands for water that is available, of quality, and accessible. Aqua obviously means water, but this is just a conceptual framework to assist the reader to understand what we mean by a right to water. Available, is it economically available? for example. Quality, there are certain indicators of the quality of water. Accessible, the World Health Organization, for example, has already identified the guidelines as to what is regarded as accessible water in terms of distances that people should walk, and how a certain community water placements should be made and so forth. And that, of course, would feed into national policy legislation by local authorities, the water utility, for example. And I focus primarily on the state as the primary duty bearer, not only because the state may be culpable in certain instances on as regards the right to water, but also because the state is primarily capable of ensuring that people can realize their right to water, in addition to non-state actors. But the non-state actor debate can happen and should happen, but for purposes of the book, the state is the primary actor of focus. This notion of the essential content of a right is something that I also identify. So under our Constitution, Article 22A, paragraph A, you cannot derogate from a Chapter 3 right, you cannot derogate the essential content of a Chapter 3 right. So for example, yes, you can limit someone's liberty, but you can't take away someone's liberty entirely. Now, the right to liberty is guaranteed under the Constitution, so that reconciles with issues such as bail, for example. There was a decision of Alexander versus Minister of Justice in our courts, where the extradition law at the time limited or prohibited the granting of bail for someone who was facing extradition. And the court found that such a limitation under statutory law was not permissible because it eroded the core of the right, that essence of the right. So each and every right has a minimum core and a circumjacent. And this minimum core is what I think and put forward as what is immediately realizable by the state, failure of which there would be limited reasons why a court should accept the erosion of that essential content. Now, what that essential content is up for debate. Is it a given quantity of water? Is it a given distance? Is it a given cost of water? That is all within the realm of debate. And then, of course, there would be other general obligations that are programmatic and subject to judicial accountability as well, to varying degrees under this notion of progressive realization, where states often put forward the fact that resources are limited and therefore certain projects would require time to fulfill and so forth. Yes, progressive realization can be a yardstick, but there can still be accountability and oversight that is exercised by the courts in ensuring that such general obligations, in addition to that non-derogable minimum core, are realized within the shortest amount of time. So those were my remarks in terms of providing an overview of the book. Please, the book is meant to induce conversation, to trigger thinking around these issues. I welcome critique, commentary, and engagement with the book. Please feel free to engage with me at the indicated Twitter hashtag. Ubuntu through water, for those of you who tweet, is what we're using to carry forward this conversation. And please do feel free to acquire a copy of the book. And let's keep the conversation going with the primary view of ensuring that each and every individual realizes their sense of dignity, their sense of Ubuntu, as regards this very important social imperative of water access, security. Thank you.
Wow, that's given us a lot to think about. So many points were raised. What I wanted to do now is introduce Advocate Bience Gawanas to us. She's a very well-known personality and character who served Namibia in many different guises and also served the African community and the international community. She's an advocate. She was the first woman to become the ombudsperson in Namibia. She's also the former African Union Social Affairs Commissioner. So that's very relevant to this discussion. In addition, she's a former UN Under Secretary General and a special advisor on Africa. These are all amongst other positions she's held. So this right to water would be absolutely within her remit. And we're very privileged to have her, especially that she's able to respond immediately, which is a real challenge for anyone, even though you have all that fantastic background and you're an advocate yourself, to Ndjodi's points, because there's multiple points that he made, and it's where Bience would like to concentrate on. So what I wanted to do is ask her to come and she'll respond to Ndjodi's presentation. Then after that, we will take questions for both, for particularly Ndjodi, but also for Bience if you wish to, from you, the audience here, and from the Zoom, a few questions from the Zoom audience as well. So can we give Bience Gawanas a big round of applause, please?
Thank you very much. And firstly, congratulations, Ndjodi, with the award. You deserve it. You know, I wish you were born a bit earlier and that this book was written during the time that I was ombudswoman and commissioner for social affairs. And being the social justice warrior that I see myself, I think it has helped me to somehow understand some of the challenges that I had in terms of dealing with, you know, human rights issues in general. But for the longest of time, Ndjodi, when we were talking about human rights, it was always about the civil and political rights as those that are contained in the Bill of Rights and therefore enforceable. And then you had the social, economic, and cultural rights that were merely state principles, putting some sort of obligation on the state and, you know, maybe working on the state's conscience to provide those to the people of Namibia. And you are actually telling us that, no, it doesn't need to be that way, that the one feeds on the other. And I remember when we always used to say that people don't, or even our president keeps on reminding us that people don't eat or eat democracy on a hungry stomach or something like that along those lines, if you can recall. And so, you know, and so for those of us that have always argued that we cannot have the luxury, what I call luxury, and I'm not diminishing the importance of civil and political freedoms, but we cannot have the luxury in a Namibia that has embarked on a struggle for the longest of time to create a better life for Namibians. To still say that, look here, you can have freedom of association, you can have freedom of speech, you can have all the others, but unfortunately, we cannot provide you with water. Unfortunately, we cannot provide you with quality and affordable health care. Because as many people would argue, the one right feeds upon the other. And so it's a false notion that just because it said civil and political rights is maybe the easy rights. That does not necessarily put that kind of obligation on the state, whereas social, economic, and cultural rights definitely requires much more than just providing a court of, a court of law. But more than that, Jyoti, I think when people go to vote, when they go to the ballot box, they are voting because politicians have included in their political manifestos many promises. They go to the informal settlements, they go to the rural areas, and they promise people that they will have access to water, they will have access to sanitation, they will have access to food and shelter. And those political manifestos, actually for me, is a social contract that when that political party gets into power, it enters into a social contract. And that is the contract, Jyoti, that puts that obligation on the government to provide to those that voted it into power a dignified life. It's that social contract that actually calls for respect, protect, and fulfill. But most times we will go and vote again and again and again without having access to clean water. We will go and vote even if it means watching your daughter being snatched by a crocodile and fighting the crocodile. That child and that woman didn't need to be in that river if they had access to water. And we feel sorry and we will, but no one will raise the fundamental issue as to why is it that Bience Gawanas can today sit and have running water in my house and others don't have that? Is it because of class differentiation and the extent to which that class differentiation also makes us enjoy our fundamental rights? So I am saying there is definitely a social contract, whether or not that the right is enforceable or not. That is the argument that I will come to, later on. But I also want to talk about the issue of natural resources. To whom does the natural resources in Namibia belong to? To whom does it belong to? The water, the fish, all those. Does government hold the natural resources in trust for the people? Water is a natural resource, isn't it? To whom does it belong to? Does it belong to the NAM water or to what is this? All these entities that are selling water, etc. I'm obviously not getting into the point of saying it must be free. That's not the point. The point is that it is a natural resource held in trust by the state. And so for me, it is going to be, in terms of accountability, I would argue that it's about how do we manage our natural resources? How are we accountable for the use of these natural resources for the greater public good? For people to live in dignity and taking care of people's well-being. So that would be my argument. And I would say that definitely, as Jyoti points out in the book, we have transformative constitutionalism. And transformative constitutionalism has said, we want to break from the past and create the Namibia we want. 31 years later, the question is, do we have the Namibia we want? Have we dealt with poverty, with inequality? Have we dealt with the issues raised by Ndjodi? And I would say, no, we have not transformed. Or if we have transformed, then there is something fundamentally not right in terms of how we interpret. And that's why I'm saying, I wish this book came out at the time that I was still, I'm retired now. When I was still out there and I could have taken a leave, because it makes us question some of the things that we have just assumed, that because it's state directives, therefore you cannot go to court and enforce them. But Ndjodi is pushing us to think differently. Is pushing us to say it's all about how we interpret and how we go forward with that. And then I want to just say, I've always said that peace is not the absence of war. Peace is the absence of poverty, of inequality, of deprivation. And the reason why I'm saying so is, if you look at the conflicts on the continent, the conflicts are brought about. If you look at the root causes of the conflict, many of them relate to scarcity of resources, of people fighting each other, either land, water, those resources. And so we have an opportunity to say to ourselves that prevention of conflict is better, isn't it, than managing a conflict. And therefore it is imperative that this kind of questions that Ndjodi has raised, that we really, especially the legal scholars, and it's not really limited to legal scholars, it's all of us, to continue to engage with these issues so that we can concretely and justifiably rectify the past legacies. Now, just finally, I love the concept of Ubuntu. And I have always said there must be something missing in our legal system, when all I can refer to is case law of Europe. There must be something wrong. If I cannot refer to the way that our people resolve disputes, the way that African people look at issues. And so when we were doing the law reform and we were talking about the coexistence of two legal systems in Namibia, you ask yourself the questions, is it really coexistence of two legal systems? Or is it coexistence of a dominant and a subordinate legal system? And once again, Ndjodi is saying, African values matter. African values matter, and more so, Africans are about solidarity. It's about community. And it may be time that we actively engage with what he is putting forward. Obviously, Ndjodi, I did not have time to read the whole book, but the little bit that I read, I find it very, very interesting. And really, I hope that you will find the time to read it and to take further He is not providing us with a magic wand. He's not saying that this is the only solution going forward. But from where we are to where he is taking us, I think that most likely is what people want to talk about, a developmental state, a state that has got a social contract with its people, and a state that will protect, that will respect and fulfill, so that people's dignity as enshrined in our constitution can be promoted and respected. There is no dignity without a right to water. Thank you.
That was absolutely brilliant. How to talk off the cuff and cover so many vital points. I'm sure we're all very impressed. It's raised so many issues. I'm not going to repeat what either Ndjodi or Bience have said, but now's an opportunity. If you'd like to raise your hands, if you've got a question you'd like to ask either of them, now's your opportunity. And we have a roaming microphone. Also, just before anyone makes their question, we will have books for sale, and I think it's at a special price tonight of $350. It's normally $395, and I think we have some books for sale, right? Yes, we do. They're here. They're here with Isidore. Oh, we have a whole heap in the car. Okay, we have a whole lot. So, and he can sign them as well. Okay, who would like to ask a question? Yes, please.
Hi, sir, doctor. Thank you very much for a very interesting talk. I have sort of a two-part question. I understand that obviously your research is delimited to be able to do a doctorate and then write a book. My question really revolves around what does it extend to? You know, can how you perceive water become a way of reorganizing society more broadly? What other things does it extend to? And then is there a possibility for extending it beyond sort of the anthropocentric view, you know, maybe using the argument that you're looking at the rights of future generations or, you know, of other species or things like that. Thank you very much.
We could take another one if Ndjodi takes notes on what was being asked. But the gentleman here, and then yourself. Yes.
Okay. Thank you. Ndjodi, my name is Lamek. I'm a lecturer at NAST. I've actually enjoyed reading your book. Although I'm a computer scientist, something that I've learned a lot from it. And on page 5 of your book, you talk about, though there are few reports of death and dehydration in extreme circumstances, there have been reports of such, going then to page 6, of deaths of people being buried alive while they were digging for a well in Ohangwena. And also, you have also talked about people in Ohangwena region who were using urine yeah, you know what I'm talking about. So how can, if there's then this implied right to water in our constitution, how can these people seek remedy given, you know, how our legal system is it's organized? You know, will they continue to just stay without justice, or what alternatives are there for them? And then my second one is more philosophical, in the sense, after reading the book on page 63, where you are defining Ubuntu. And then when you define Ubuntu, you defined it as something that our ancestors have passed on, and it continued to be passed on with generations. How do we pass Ubuntu with its communal values to the next generation without losing the essence of Ubuntu. And if the essence of Ubuntu get lost in how Ubuntu get transmitted to the next generation, that communal essence, will the right to water still then be implied if Ubuntu changes? Thank you.
Wide-ranging questions. Would you like to ask your question? I know it'll be on natural resources. Yes.
Thank you. Thank you both for a wonderful contribution speeches. Thank you. I'm Bertien Koos from Earthlife Namibia, and I want to ask you what your judgment is about legislation on Namibian groundwater, and I'm speaking especially on groundwater. And the reason that I asked this is that we experience presently in Namibia a planned project to in situ leaching of uranium in a very important artesian basin, actually the Stamford artesian basin. And so why is it allowed according to Namibian legislation? I was told that, for instance, in South Africa, it is legally not approved to do this. And I mean, Namibia is as water stressed as South Africa, or maybe even more. So yeah, what do you think about that?
Bertrand, is that question addressed to both of them, or is it addressed to Ndjodi?
To Ndjodi, if I might say so. Yeah.
Okay, thank you very much. There was another hand up. We had the first gentleman, then Lamek, and then Bertrand, and then there was Michael. Was that you? Yes, Michael.
Thank you, Ndjodi, and also Advocate Bience Gawanas. I have a question for both of you. For Ndjodi, I would just like to know what has been the sense of reception towards your thesis that you put through, particularly given that you use decolonial theory as the basis of your thesis, and in many ways, it's almost as if African values were also interpreted in a pejorative sense. And is it received well, or is there a struggle? And the reason I ask this is almost to say that African values in many ways are still seen, or they're trapped behind this colonial veil. And they are undermined, they're looked down, and they're not necessarily put out there, irrespective of their, I think, the contributions that they make towards society, globally speaking, or in a global sense, or perhaps in a West-centric world order. And then for Advocate Gawanas, could you perhaps maybe just speak a little bit more on where do the rights of the natural person begin and that of the states, particularly when it comes to ownership of resources? Because we say these resources belong to everyone, but where do we draw a line? Where does it begin? Where does it end, etc.? Thank you.
Okay, I think that's plenty to go on with for both of them. And Jody, would you like to come and respond to them? Could you respond to them in the order that they were asked, do you think? And then we'll give Bience a chance to answer that last question.
Thank you very much for all those questions. They are thought-provoking and greatly appreciated. I also just wanted to appreciate the views and sentiments and time of Advocate Gawanas. Much food for thought there. I greatly value the fact that she is deliberate about intergenerational conversations, bringing together different generations in conversation with one another, and us understanding the thinking of the time, not in a judgmental way, not with necessarily the benefit of hindsight, but with a view of moving forward. So thank you very much for those reflections, Advocate. So the first question was around the extent to which So the anthropocentricity point, in terms of how the discourse will develop, future generations, species, and so forth. So the book, as I mentioned, focuses on human beings at an individual and community level, and deliberate about that. It's interesting. That's a contemporary debate right now, where people are thinking about how do we share the resources that we have with non-human species and so forth. But in as much as that is an important consideration, I decided to focus on individuals and communities because of the lived realities that countries such as Namibia specifically face, right? And I think the purchase of an argument where individuals and humans are suffering water deprivations and still have limited access to water, in a way you are then arguing for species, flora, fauna, and so forth, and even future generations, when you can't satisfy current generations, would have limited appeal in a Namibian context. So that is an important discussion that we should have, that we should be thinking in the direction of, and that's the whole notion of effectively sustainable development, right? Which is in the edifice of the language of particularly Southern African developmental direction. So perhaps an area for future focus. Moving on to the question by Lamek. Lamek, you have me on speed dial, so I don't know why you would pose such provocative questions on a public platform like this. But be that as it may, we've engaged many times on these subject matters, and I appreciate the fact that you always bring critical and thought-provoking perspectives. So on this issue of the examples that I cited, in terms of there are people who are actually suffering very basic water deprivations. So that is something that I did not want the reader to forget, because sometimes it's at the meta level, but we forget that there are communities that continue to suffer the very basic water deprivation. So yes, people are not sort of dying, walking because they don't have water of literal thirst, but we're not far too removed from such a situation. And that is what I wanted to bring in the consciousness of us, especially when we move towards that notion of a minimum core. The idea is really for the approach that I took in writing the book is really for people to help themselves, to recognize that help is not going to come from far away. There's no savior necessarily who's going to then turn on the magical taps and sink the boreholes if you do not or are not empowered to help yourself. So the book is meant for people to at least ask the right questions, have the right tools to understand what the issues are, right? So if you are in a public forum, you bring to the fore a well-rounded, well-understood argument that is centering the right to water when you're deciding how to distribute the limited water resources that there are, then your argument will hopefully have much more currency. Again, perspective of thinking, as Advocate Gawanas has clearly outlined, and also to feed into policy, into law. So lawmakers hopefully do take this piece of scholarship seriously for what it is, and then that can hopefully enrich them and their development of policy that can be informed by the arguments put forward in the book. To the second point of Ubuntu, yes, there's a whole discussion of Ubuntu, the fascination thereof, and the weight of the argument. Next generations, the whole edifice of Ubuntu is within our constitutional framework. Article 66 protects the customary law, ostensibly on par with the common law, but in reality, the common law is far superior. We barely have customary law mainstreamed. This is an argument to mainstream customary law, at least bring some parlance between customary law and common law. the notion of customary law is that it's dynamic. It changes with generations. It's not static. That's the beauty of it. So we can't necessarily impose upon future generations that this is the idea of Ubuntu that is permanent and cannot be changed. But I think they would benefit from this generation and previous generations' understandings. And if we were to inculcate that culture of African values in mainstream legal thinking, in our jurisprudence, in our case law, normalize that, I think we can then move forward in realizing that a notion of transforming society from the society that we inherited at the dawn of constitutionalism to the society that we still envisage, have not yet realized, and that can be closer to home. Thank you very much for the question on groundwater sources. I think that's an important debate. And again, I think there are some tools here that you can perhaps look at in terms of answering some of those burning issues. So the groundwater legislation, I haven't necessarily looked at the legislation on water in Namibia. I did look at it at early stages of my research particularly, but I decided to veer away from a statutory basis for a right to water to a constitutional right to water, because statute is effectively subject to the will of the democratic majority of the day. So yes, you can have a progressive piece of legislation that promises all sorts of water rights, but that is just one electoral cycle away from being taken away from the individual. So in building an argument that is implied from a right to life that is entrenched, then that has much more permanence. And the only way you would, in theory, be able to take away such an implied right to water is if you had done away with the constitution entirely. You know, feeding into, for example, the property debate in the country. You know, how do you reform the land system where ownership is protected by the constitution? You can't change Chapter 3 rights and so forth. So the protection of Chapter 3 is what I want to give the right to water. But this issue of abstraction and contamination of water isn't unique to Namibia. And there's a case study that I include in the book, and that is from Nigeria. In the early 90s, there was this decision by the African Commission on Human and People's Rights. The circumstances were such that a certain oil company was operating in Nigeria. At the time, there was a military government in the Ogoni area, Ogoni land of Nigeria. They were contaminating the water sources. They were effectively depriving people of their food and so forth. This is one of the seminal cases where the African Commission had recognized socioeconomic rights as court-enforceable. Yes, it did not recognize a right to water expressly, but it did recognize a right to food, and that there was a violation by a non-state actor, in as much as that non-state actor, the oil company, was in cahoots with the government of the day in Nigeria. So yes, particularly when it comes to mineral resources, it's non-state actors who are often involved. But then, because it's a non-state actor, it doesn't mean that the state then can play a passive role. It still has a respect dimension to its duty. So, and a protect dimension to its duty. So it has to put in place legislation. It needs to ensure that water sources are protected for future generations, for current generations, not only for the commercial benefit of mining entities, for example. But that discussion and the tools therein are primarily found in Chapter 6, so I would implore you to perhaps engage there, and the sources that are referenced in the chapter. To Michael's question on the reception of the thesis come book, it's been fascinating. I'm still, testing the grounds as to how well received in Namibia it is, but by your attendance, at least it's encouraging. But I've had several book discussion and launch events in the United Kingdom, where I currently reside. And I'm fascinated. Firstly, the Subedi Prize, which is the prize that my thesis was awarded for, the best law thesis. I found it fascinating that a subject matter that is based on African values, firstly, that reflects on the issues that affect Namibia, secondly, and that focus on water as a human right, was identified as worthy of that prize. Now, so of course, the water debate is very important inherently, and it's globally relevant, and it's only going to become more pronounced. And that's why hopefully this book is timely and both timeless. But it's interesting that in engaging non-Africans, Europeans, and the scholars that we are in community with in the global north, they found great fascination with these notions of Ubuntu. And sometimes there were sort of like eureka moments of like, oh, you know, there's this fascinating concept because, you know, and that feeds into decolonial or colonial thinking, the legal imperialism, as I define it in the book, that the epistemic arguments that were put forward reduced African peoples to peoples who cannot regulate themselves because they do not have the tools of self-regulation. And I push back against that by invoking a ubiquitous value such as Ubuntu. So the reception, at least in the global north, has been fascinating. I hope the reception in Namibia is equally met with intrigue, with curiosity, with a desire to ask the right questions, not only of our local communities and those who have those responsibilities, but also judicially. And hopefully that can feed into strategic litigation that can see us having a decision of note where our superior courts recognize expressly that there is an implied right to water, and hopefully they'll cite me as a but so that is sort of culture that we are trying to push back against and inculcate a new dynamic way of thinking, both locally, but also demonstrating that globally we have local solutions that can offer perspectives to global issues such as water. So I'll end there.
Thank you, Ndjodi. Now, for the second part of that question was addressed from Michael to Bience Gawanas.
I think I would like to on the issue of African values. If there is something that has happened in the last 2 years with the Black Lives Matter movement and George Floyd, it has put every organization on notice of racism within the organizations and the extent of colonial legacies. And colonial legacies has got to do with organizations in the global north always thinking that they are there to save us in the global south. And that has permitted organizations and the way organizations look at people like myself. And I think we have moved on since then, and we are saying, I am who I am. You accept me who I am. I was excluded by apartheid, not because I had less intelligence than a white child. I was excluded because of my color, but my intelligence is still exactly the same. So that is basically where we are at. And so we, you know, the whole discussions around the African Renaissance, but it takes us as Africans to start speaking our language, and I'm not talking about Damara, Nama, or Herero, I'm talking about whenever we talk culture and African values, you know what happens? Everybody talks about harmful traditional practices. And it's always the negative aspects of our culture and our values that are being emphasized. And yes, there are bad ones. There are definitely bad ones when it comes to gender equality issues, and we call into to aid our, our culture when we are talking about, gay rights in Namibia. We call on our culture. I think those are the things that we need to fight, but definitely there are positive cultural practices that we should not discard for the sake of modernity. And that is where I was talking about the coexistence of the two legal systems. And I think it is high time. And I hope that the Law Reform and Development Commission, or everyone that is busy with it, can really hasten the time that we will put or give equal weight to customary law issues. On the issue of natural resources and rights, I don't think we should look at, oh, I own this mine, or I will own this, what do you call, fleet of fish, or what do you know, it's fleet, it's not fleet of fish, school of fish. What I said was that the state holds natural resources in trust, and we know that a lot of the things that government does is, for example, it has to raise taxes, and taxes has to build schools or build hospitals, etc. My point that I was trying to make is, how do we hold our government accountable for the effective utilization and management of our natural resources for the benefit of the people? A case in point, and that makes me very angry, and I know people are innocent until proven guilty, but fish rot. I have said, when we talk about these issues, we need to fight corruption. We need to fight corruption because it undermines the very resources that are supposed to be for the benefit of our people. And so it's just the question of transparency, accountability, and the proper management and utilization of natural resources for the benefit of our people. There is just no justification that a country like Namibia cannot provide a higher and better standard of living for its people.
Thank you very much. Well, that was very wide-ranging. Can I ask Ruth, are there any Zoomi? Is there? No, there isn't. Okay. Valdi, we haven't had people from this side of the room, this side of the space asking. Have you got a question yourself? Yes, please go.
So my question, I'm Valdi from Namibia Scientific Society. I speak as an ordinary Namibian citizen now. My question is a very basic, practical question, and I apologize to all the legal, highly qualified people for not being able to rephrase it in the appropriate terms. If I were a citizen in the second largest town in Namibia, being Rundu, I sit on a river, and the government is not able to provide sufficient water as we had recently. And I revert to the traditional way of utilizing the water in the river and find that the water is more and more polluted. And we are heading for a disaster. If we look at the development in that river, then what would be the situation in legal terms? It's me against the community who is maybe responsible for pollution against the government, which cannot provide potable water. How do you manage such a situation?
I ask Ndjodi to reply to that. Is there someone else who would like to ask a question? Yes, in the denim jacket. Would you like to ask your question? Thank you.
Thank you. Good evening. Thank you so much, Doctor, for that very comprehensive presentation on your book. My name is Ndilo Kelwantengwe, and I think I don't necessarily have a question. I think in the spirit of how you've also presented, it's really around provocation of consciousness. And I think I'm linking it again at the cusp of also gender justice issues in the country. And I think what I've written here is, especially from what Advocate Bience was talking, is really making the link for the right to water to reproductive justice, and the extent to which inaccessibility, quality, and availability of water infringes and undermines this specific right, as reproductive justice is very, very clear on one of its core principles on the right to raise a child in a safe and healthy environment. Now, if access to water is limited, and if households are consuming unsanitary water, then this specific right cannot be realized either. And this kind and level of indignity is unconscionable to even hold as a single thought at this point. And I think it was really just putting that in thought and in writing to later on explore and interpret further, as it's definitely provoked a lot of consciousness at the cusp of this gender justice issues that we're also facing. Thank you.
We look forward to seeing an article by you on this same topic in the Namibian on a Friday. Is there another? We take one more question, then that would be 3. Oh, there's 2 more. Okay, 2 more, and that probably would be it. Was one here, the lady here, and then there's yourself over there. Thank you.
Right. My name is Linda. First, I think I must congratulate Dr. Ndjodi for bringing this debate to the Namibian community or to the Namibian population. I think what I want to ask, or maybe my question, it's really coming from a non-legal person. But I just want to pick up from what advocate was trying to advocate, I think. The social, the social agreement, for example, that the political, for example, movements or parties normally make promises through their political manifestos during election times. My question is, if these political parties do make these promises and they do have these written manifestos that they present to the potential voters, you know, when they do their campaigns. And surely there are communities who have been promised like water since 1990 up to now. My question is, taking into consideration that right to water is not expressed in the, it's not expressed in the Namibian Constitution, though it can be implied, can those communities go to court and hold these political parties accountable? More especially, let's say it's the political party which is now got into power, and then the communities can say, yes, you promised us that you're gonna provide us with water, and we have voted you into power. Yes, you are now in power, you know, and they have their manifesto written. Can't they be held accountable or hold accountable based on that? As I said, my question, it's really from a non-legal person, but I think I tried to just make my point or my question quite clear. Thank you so much.
Thank you very much. The last question, a friend over here in the white.
Good evening. My name is Lovisa, and I live in Windhoek, but I'm from the Omsati region. And And I'd like to thank Ndjodi for the great introductory presentation into the book. I was quite interested by sort of the aqua available, quality, and accessible as key attributes to basic human rights to water. So, and this brings me to a case of the Kalueke Oshakati water canal. Scientists, they stated that due to climate change, that the Kalueke Oshakati water canal is under threat due to evaporation loss. And as a recommendation, there's been plans to rehabilitate or to pipeline the water, but this has been heavily contested by local authorities. So I just wanted to pick the doctor's brain on this. How does the book address this?
Two questions and one comment? No, 3 questions and 1 comment. Vuldi, your one, and your final one, and then the comment from the journalist, gender justice lady. Okay, but Ndjodi, could you come up? And then if Bience also wants to comment, particularly on the reproductive rights bit. Okay, thank you.
Thank you very much to everyone for those questions. That's the exact sort of consciousness and thought provocation that the book is intended to achieve. I'll link Valdi's question with Lovisa's question because I think they both identify practical issues in society which affect different communities, but have a common thread, which is these communities are suffering water stress, water insecurity to varying degrees. Now, the book really just provides the tools for you to answer those questions for yourselves. The aqua notion is a conceptual approach that I think can at least be at the tip of your tongue when it comes to thinking and articulating these issues. So how does that situation in Rundu, for example, reconcile with the issue of quality of water, the QU in this notion of aqua, and the responsibilities there that Waldy was identifying? Yes, the book focuses on the state as the primary duty bearer, but there are other actors who also have a responsibility. And again, the communities have duties, and this whole notion of duties is actually something that is worth focusing on in the context of African understandings of human rights, because the African Charter on Human and People's Rights is unique in that its philosophical underpinnings recognizes that African philosophical thinking requires that people do not only have rights, but they also have duties. I place those duties at the level of the state, but those also extend to what we call in legal parlance horizontal duties, so duties between individuals and communities, rather than vertical duties or vertical relationships between the state, which is clearly superior, and the subordinate citizen. So that is definitely something that we should also interrogate, that sense of responsibility that communities have towards themselves, building that consciousness. I think the issue of water pollution, and of course the extent of water pollution by through non-commercial small-scale means would vary in degree, right? So inculcating within people that they also have a responsibility to those water resources, not because a piece of legislation says so, but because the values that dictate their everyday lives, that dictate their interpersonal relations with one another, which include values such as Ubuntu. And I've sort of offered an anthropological analysis of Ubuntu as it relates to its various linguistic renditions in African communities, including since you mentioned Rundu, the Tsiriku people, who also have a a notion of Ubuntu, which effectively is expressed in their own language, that there is also that primary responsibility. So on the Kalueke situation, Lovisa, perhaps this is where a scientific and legal mind should come together to see what can potentially be done. But again, it's a question of consciousness, and hopefully this book offers you and those communities the tools to answer such perspectives. On Ndilo Kelwa's question, thank you very much for that enriched perspective. Of course, the book is attempting, but I must say in certain respects failing to be intersectional in its approach. But the intersectional dimension, I think, lives itself out most greatly in chapter 4, where I discuss the right to water from an international law perspective. I include an analysis of various treaties that are specific to certain protected categories, which include women. So CEDAW, the Convention Against the Convention for the Elimination of All Forms of Discrimination Against Women. It includes the CRC, the Convention on the Rights of the Child, and all those instruments, of course, make reference to reproductive health issues. I focus, for purposes of the book, on the issue of health and its relationship to water, because obviously without water, your health needs are generally eroded. And in thinking of how to anchor my implied right to water, I was thinking, should I derive it from the right to health? But in a Namibian context, it is a challenging argument to make, because you would be implying an implied right to water from an implied right to health. So hence the reason why I focused on the right to life. But I think there's a lot there, and I think intersectional thinking in that direction is very important. And of course, the reality is that if you solve water issues for half of the population, so the female side of the population, you've almost solved much of the problem, right? Because the burden as it relates to water is often on the shoulders of women. So that is something that is also emphasized in the book. On Ms. Shanika's question on the social contract, yes, that's a fascinating perspective. I think you will provoke your political constituency if you bring those ideas to the fore. But that's exactly the sort of thinking that frustrated me, where I feel that Namibian votes, especially in rural communities, are too cheap. People are promised things that are very basic, but those very basic things are often not provided, unfortunately. So the book is really meant to bring consciousness to people, to bring more currency to their votes, to say that, no, my vote is not just going to equate to your promise, often unfulfilled, of a pipeline from A to Z, so I can have can only walk a distance of 5 kilometers as opposed to 10 kilometers to access the nearest water hole. But this is your obligation, and irrespective of who you are as a elected political official, you have that responsibility. And if you do not carry out that obligation, I can seek refuge, and such refuge can be found through the courts. And in directing you more specifically as to where that discussion can be found, if you turn to chapter 5, the discussion at around page 168 to 174, I typologize the issue of justiciability by focusing on enhancing participation, equality, and representation when it comes to water. And that whole notion is developed with this understanding that oftentimes there are the voiceless, but in actual fact, Arundhati Roy, the famous novelist, reminds us that there's no voiceless, there are the preferably unheard, those who we have muted or we are muted to as society. Now, those preferably unheard people, I argue, should also have the protection of our courts. And it's the responsibility of our courts to ensure that they do bring dignity to their lives by stressing that the Constitution can also speak up for them in terms of the socio-economic realities that they face. And to conclude on that point, it's interesting because, yes, it's an implied right to water now, but actually a very progressive and potentially compelling political platform is to amend Chapter 3 to include the right to water expressly. So the Constitution prohibits you from taking away from Chapter 3, so you can't expropriate without compensation by taking away the compensation element, for example, but it doesn't exclude you from it. So it excludes you from derogating, but it doesn't exclude you from enhancing Chapter 3. So you can say, oh, actually, there are these progressive approaches to rights that are now recognized. We're going to add a Article 6 bis, for example, which is specifically speaking about the right to water. And then, at least in the consciousness of people, they have a textual basis where they can say that, oh, this right is an actual right. Because now, you know, you have to go read Re-invigorating Ubuntu through water in order to understand that you actually have a right to water. Whereas you can just pull your constitution out if there was an express right, which, you know, is a preferred position. So if you have political ambitions, that can potentially be your political platform. But thank you very much for those questions.
It's been an extremely wide-ranging discussion. I want to ask Bience if she wants to make any final comments.
There are obviously different ways of holding government and politicians to account. One is through the ballot box, and the other one is obviously through the courts, but also Parliament. Don't forget the role of Parliament in this. In fact, so, I hope that if Ndjodi had enough money and he could publish print more copies, he should have given each member of Parliament a copy of the book as a takeaway. Or maybe we can mobilize them to buy the book. You know, when people say water is life, it really means just that. You know, when we had the HIV, I mean, years ago, it's still there, but you know what I'm talking about. And I remember I was at a function where people were speaking about the impact of, you know, HIV, AIDS, etc., etc. And a girl that was born with HIV was, it was a, you know, children's meeting, said, you know, firstly, I was born HIV positive, and I have to drink tablets. But what is the point of taking tablets that are supposed to prolong my life if I'm drinking contaminated water? You understand the dilemma? You understand the irony of it all, that on the one hand, you want to prolong life, and on the other hand, you are taking away life just because of what we are talking about. So for me, it is a fundamental issue. it is an issue that maybe at this point in time, because we had amendments to our constitution, maybe it is time that we look at these issues from the prism and from the perspective of the people, and to say 30 years, 31 years after Namibia's independence, what are the developments that we need to take into account? Because I was always made to believe that the constitution is being given life to by its implementation, by its interpretation, but most importantly, by the values that it espouses. And so the legal route is one, but I want to believe as a human being standing in front of you, that something that guides me in my life has always been the fundamental values that we grew up with. Do unto others what you want done unto you. And also to say the African Commission, the African Charter on Human and People's Rights was deliberate, because they said, as much as we are talking about human rights, we also need to talk about people's rights. And it is premised on the community, on the very things that Jode is talking about. So the African Charter on Human and People's Rights already went a long way, even to recognize the right to development that you will not find in many, many, many other texts. So really what I think Dilo said it. The book is about triggering our conscience to say to ourselves, what is it that we need to continue talking about, that we need to demand? Namibians are very, we are very, what is the word? We are very modest in our expectations and in our demands. And it is why complacency creeps in. And why sometimes you feel that after years and years, nothing moves or nothing moves forward. And I think we put maybe too much in the hands of government, too much in the hand of politicians. And I know communities have a role to play. I think when Ndjodi was speaking about our responsibility not to contaminate water, our responsibility to save water, those are also responsibilities that are upon us and not always a duty that is on government. So once again, I just want to thank Ndjodi, and I was saying as I started off that if we had written this a couple of years ago when I was in part of the Law Reform and Development Commission and as Ombudswoman and as all the others, he might have gotten somewhere, but right now I have nothing to offer you other than support you and say congratulations, and please let us engage, let us debate. That is the purpose of us being together here. Thank you very much.
Thank you very much, Bience. Can I ask the gentleman, apparently you wanted from the Water Ministry, MAWF, isn't it? Yes, just come and you wanted to make a point about the work of the ministry in water.
Well, it's usually and naturally uncommon to find somebody who is taking photos to be the one saying something. It's very unusual. At any event, you don't expect it. And sorry for surprising you. I did not prepare anything, any special remark. But maybe before I proceed, my name is Jonah Musheko, the spokesperson of the Ministry of Agriculture, water and land reform. I came here, I thought in my personal capacity, but as they say, you can never detach yourself from your employer. So even when I'm drunk, I'm still the spokesperson. So I have to behave even when I'm here in my personal capacity. The only thing I can say is that your work is appreciated by the ministry, and also apart from appreciation, as my responsibility, I will make sure that this book reaches the right minds. I'm very glad to say that I'm not alone here during this discussion. I'm joined by the director responsible for water supply in rural areas, Dr. Ngurare, who joined virtually. And I just checked now, even before I came, he's still online following the discussion. He couldn't make it on time because he was attending what we call PC meeting. These are meetings that are responsible for procurement. As we all know that our procurement requires much attention than a baby. So I should say that your work is really appreciated, and I'll make sure that even Kalesh Letvain, who is our minister, who must be able to get a copy. Whether I have to buy it or you have to buy it, he must be able to get a copy. That is now between me and you, so that this knowledge can contribute to the water sector. With that, a few words, I appreciate for listening. Thank you.
Thank you very much. And on that note, we've just had a reminder about the book, which is over here for sale, special price of $350 instead of its normal price of $395. Can I say to all of you, thank you so much, and particularly your patience at the beginning when our guest speaker was zooming here in his brother's Mercedes-Benz from Otjiwarongo. Thank you. Baldi, I didn't know if you wanted to say anything as in final comments to thank. I'm personally thanking the speakers and all the audience. It's been a very insightful evening, very wide-ranging discussion. Thank you very much.